Good morning, everyone, and welcome to our joint webinar on post-Brexit immigration in UK, Netherlands, and Belgium. Thank you very much for taking your time out and being here today. So firstly, I would like to introduce today's presenters. So my name is Vida Lupete, and I am an immigration solicitor at Hudson McKenzie. I will give a brief overview on immigration changes in the UK. And I'm also joined here by Juliana van Gulik, who's an immigration manager at Dutch Belgian, and Kirsten Krawinkel, senior immigration consultant at Dutch Netherlands. So we will be running a live Q&A session at the end of this webinar. So feel free to post your questions in the chat box or leave it till the end of the presentation, where you will be given a chance to unmute yourself and ask a question. Okay, and if you miss anything, don't worry. The webinar is being recorded and we'll be sending out the on-demand recording when it's available. And it will also be available on our YouTube channel. So just to give probably an extra minute or so for the rest of the attendees to join, I will quickly go through the agenda that we are going to touch today. Okay, there you are. Okay, so I will start with the UK immigration by covering recent changes, such as, why we need a sponsor license. I will talk through skilled workers and ICT visas. I will go through the business visitor visa, as well as EU settlement scheme for those EU nationals already in the UK. And I will finish off with frontier worker visa. Then our partners will cover Belgian immigration. They will talk about the importance of immigration planning, work and single permit, cross-border workers, and if there are any exemptions. And on a Dutch immigration, importance again of immigration planning, recognized sponsorship, highly skilled intra-corporate and EU blue card visas, short-term and cross-border workers, and again, if there are any exemptions. And we'll finish off with, as mentioned, with the Q&As. Okay, so those who just joined, again, welcome. And I will start with the UK immigration changes. So the recent changes to the UK immigration were really the end of free movement for EU nationals, which ended on the 31st of December 2020. So those who resided in the UK on that date or before that, they had time up until 30th of June to apply to the EU settlement scheme. Okay, the new points-based system came into effect in December 2020, and it is applicable to EU nationals who's arriving from the 1st of January and who's not eligible to apply to the EU settlement scheme. Okay, so the sponsor license applicable to companies who are willing to employ migrant workers, and they need to hold a sponsor license to be able to sponsor migrant workers. There are certain activities that are permitted under the withdrawal agreement, such as typical business meetings. In addition, there are certain exemptions that allows EU nationals to come to the UK to perform certain duties. Just to name one is, for example, the manufacturer's clause, that allows employees to come to the UK and install the product that the company manufactured. The exemptions can be tricky, so it is definitely recommended to check with an immigration expert whether the proposed travel purpose would fall under any of those exemptions. So the sponsor license itself is applicable to established UK companies and allows the company to sponsor migrants. When applying for a sponsor license, the business must appoint key personnel such as authorizing officer, key contact, or level 1 and 2 users. Those roles carry certain duties that person must undertake. Additionally, the company must have a robust HR system in place for record-keeping purposes or to track migrants' absences, for example. It is very important that compliance is maintained, as the company may be audited throughout the time they hold a sponsor license. So the initial license is granted for 4 years, and afterwards you can renew it, and basically Home Office can audit the business at any time, including when the business applies. So when the company applies for the sponsor license, they can perform so-called pre-license audit as well. There is a possibility for an umbrella company to hold a sponsor license, who can then sponsor migrant workers and subcontract them to the client's site. So skilled worker visas, previously called Tier 2 General. Okay, there are certain changes that came again into effect in December. So the minimum salary threshold, it has been lowered to 25,600, or the rate as per skills occupation code. So it depends on the job that the person is coming to perform, that the salary would need to be assessed. Also, there is a minimum skills threshold, which is equivalent to national qualification framework level 3, which is equivalent to A levels. They do not necessarily need to hold the qualification itself, but the job just needs to be on that minimum level. Okay. In terms of the minimum salary, workers may not be required to meet the salary threshold if they have been allocated tradable points. So tradable points can be given if, for example, your job falls in shortage occupation or the migrant worker holds a PhD degree. There is an English language requirement, so that can be met by either having a degree either from a UK university or from any other country if it was taught in English, or by passing an English language test. So the English language test, the minimum level is a B1, which is quite basic, to be honest, in terms of just meeting the requirement. Okay, and skilled worker visa actually leads to settlement. So those who willing to relocate to the UK permanently 5 years down the line, if they meet all other requirements, they can apply for indefinite leave to remain. So intra-company transfer. So this type of visa is designed to basically transfer the existing employees between companies that are linked by common ownership. There is a minimum salary threshold, which is higher than skilled worker. A minimum threshold itself is higher than for skilled workers, which is 41,500, or again, as per skills occupation code, whichever is higher. There is also a requirement in terms of the length of being employed by the company. So if the salary is less than 73,900 per year, the employee must have been employed by the company for at least 12 months prior to them being transferred to the UK. Of course, if it's higher than 73,900, there is no minimum requirement of service. This visa does not lead to settlement, and there is also no English language requirement. However, once a worker comes to the UK on an intra-company transfer visa, they are eligible to switch from ICT, i.e. the intra-company transfer visa, to skilled worker visa from within the UK, where previously, unfortunately, they were not eligible. So in terms of the intra-clearance process itself, so the first step usually is for the employer to issue a certificate of sponsorship. Once that has been issued, the migrant then submits the intra-clearance application in the country of their nationality or the country of residence. So the country of residence is quite applicable to EU nationals, because a Spanish national might reside in Italy or Poland or anywhere else in Europe, and they do not have to prove anything further than just being EU nationals to be able to apply for the visa. Where if, for example, the migrant worker is Japanese and he resides in Spain, for example, they would need to prove that they have a legal right to be in that country other than a visitor. You are not permitted to apply for a UK visa if you hold a visitor visa. So the process can take anywhere from 1 to 15 working days. It really depends on the country that you're applying from and the service that you decided to use. So for example, in the US, there are additional services available where they can use a gold service, where the visa is issued within 1 working day. But for European nationals, unfortunately, there is no priority service available. Therefore, their application process is a minimum, like a standard application process is a 15 working day process. However, based on our really recent experience, most of the decisions are made within the first 5 to 10 working days for EU nationals. So once obviously the visa has been issued, the migrant can enter the UK as per the date of this starting date on their visa. So EU nationals are not issued with any stamps or any stickers in a passport. They are issued with electronic visas. So at the border, they do not really need to show anything, and basically the visa is just in the system automatically. Where, for example, if again the national was traveling from Japan, they would get an intra-clearance visa, which is sort of a sticker, so-called vignette in their passport, and they would have to show that at the border. In terms of business visitors, I did mention that slightly at the beginning, but so standard business visit visa, you can enter the UK for up to 6 months. EU nationals do not need a visa to enter the UK as business visitors, as they are so-called non-visa nationals. But again, activities are rather restricted in terms what type of activities you can perform. As mentioned, there are certain permitted activities under business visitor rules. However, frequent visits might flag this up if you kind of traveling back and forth to the UK. At the border, you might be questioned at some point, what is the purpose of your frequency and what is the purpose of your visit? So I presume it's best to keep that in mind, and if you are traveling frequently, perhaps carry a letter just to feel safe, and so that you have something to back up, to have a backup. Apologies. Okay, so the EU nationals in the UK, we are going to an end with this. So the Brexit and the EU nationals is going to an end. So obviously everyone had the deadline to make an application to the EU settlement scheme by the 30th of June. Those who missed the deadline, the Home Office did grant a 28-day grace period. The grace period is really given to those who missed the deadline for a good reason. So, for example, if you had COVID or you were shielding, that would be accepted as a good reason, or, for example, a serious illness or anything like that. So, yes, those who actually resided in the UK before the 31st of December 2020 but missed the deadline, they can still make an application. And frontier workers. So frontier worker visa is designed to those who are employed in, who are either employed or self-employed in the UK, but they do not live in the UK. Okay, so their primary residence is not UK. So, for example, a German national, he needs to travel to the UK frequently for work. For that reason, this type of visa would be applicable. So usually the worker cannot make the UK their primary residence on this type of visas, and they are permitted to stay in the UK for no more than 180 days in a consecutive 12-month period. So to be eligible to apply for this visa, the worker must show that he worked in the UK at least once every 12 months. This visa is usually issued for with a 5-year validity, and you can bring your dependents, family members, so your spouse, your children. They can apply as well, but they would apply into EU settlement scheme under rather than a frontier worker, sort of a dependent visa. Right? Okay, so that is it in terms of UK side. So I will pass you on to Juliana, I believe.
It's Kirsten, actually.
Apologies.
It's Kirsten. I'm working with the Belgian desk of Box, and I'm honored to give you some more information on Belgian immigration. Based on our agenda, Vaida, I think this is already the first slide, not the agenda, but it's okay. So normally
I've already went through agenda.
We will touch upon some subject of which the importance of immigration planning is one. I'll also briefly explain the principles on work and single permits in Belgium. Time is quite limited today, so I focus on the main principles and give some pointers here and there. And next up are also a work permit in Belgium for cross-border work. And then we end with work permit exemptions. To start with the importance of immigration planning. So we all know now that the free movement of services and people within the EU is no longer applicable to UK nationals since Brexit. Therefore, all UK nationals are considered as third country nationals for Belgian immigration. British nationals who were already residing in Belgium before the 1st of January 2021 are considered beneficiaries of the withdrawal agreement. Also, their family members with whom a relationship already existed prior to Brexit, and even future children are covered by the withdrawal agreement. This means that they can still benefit from the rules for family reunification as before Brexit, being the rules that are applicable to family members of an EU citizen. If your British employee is not a beneficiary of the withdrawal agreement, then a work authorization will be required for Belgium. To obtain such a work authorization in Belgium, you have to take into account that there are additional processing times, additional government fees that can take up to more than 500 euros, and additional salary and even educational requirements. The next slide, yes. Therefore, UK nationals, but also their employers, they have to be aware of the fact that work authorizations are required if they want to be professionally active in Belgium. In Belgium, a single permit is needed for employment of more than 90 days. It is valid for maximum 3 years, and it is a combined work and residence card, which is to be applied for simultaneously at the Ministry of Work of the region in which the employee is mainly active. If the employee is active in several regions in Belgium, because in Belgium we have 3 regions, being Flanders, the Brussels Capital Region, and the Walloon region, the Ministry of Work in the region where the employer is located is competent. An important remark is that the single permit needs to be in place before the commencement of the activities in Belgium. It is thus not allowed to have your UK national work in Belgium under the visa waiver program and as a business visitor, and then subsequently employ him and do productive work in Belgium. So if that is the case, you need to have the single permit in place as from the first day of work in Belgium. The application process and practice takes about 6 to 8 weeks time, but the legal term is fixed at 120 days. This period does not include the time that is needed to gather all the documents that are required to apply for the single permit, such as a medical certificate, a police clearance certificate, and if family members are accompanying the employee, also birth and marriage certificates that needs to be legalized. Therefore, we always advise our clients to apply for a single permit about 4 months prior to the actual start date of the activities in Belgium. The most commonly granted categories of a single permit in Belgium are the highly qualified employee, being for workers who earn at least about 43,000 euros gross per year. It depends on the region. And also in the Flanders region, a commonly granted category is the bottleneck professions. There is some news regarding the ICT permit because we expect this to enter into force in autumn 2021 in Belgium. And the ICT permit allows non-EU nationals who are seconded to a group company within the EU to benefit from relaxed work and mobility regulations within the EU. More information on this type of permit will be available later this year. Even though UK nationals are or can benefit from the visa waiver program, meaning that they can travel to Belgium without a visa, we still advise our clients to apply for a type D visa when they come to Belgium to work for more than 90 days. This type of visa will facilitate the registration process at the town hall, especially for employees coming to Belgium with family members. A single traveler could still regularize his registration at the town hall without a visa, but this is to be checked on a case-by-case basis, so we always advise to double check this. Lastly, we also would like to inform you that a highly skilled single permit holder is eligible for a more permanent single permit after having worked in Belgium for 4 years. And after having worked in Belgium for 5 years, he can be eligible for a permanent residency, after which even Belgian nationality can be obtained for. The work permit is, and compared with the single permit, the work permit is needed for employment of less than 90 days. And it is known as a paper blue card. The same as for the single permit, it is to be applied for at the competent region, so Flanders, Brussels Capital, or Walloon region. It needs again to be in place before the actual start date of the activities in Belgium. The work permit is, it's far more easy to obtain than a single permit. The processing time is also 1 to 2 weeks at this moment. Again, not taking into account the time that is needed by the employee to gather all the documents to apply for the work permit, and for us, obviously, to make the assessment which type of work permit is needed. We advise our clients to apply for the work permit about 1 month prior to the actual start date of the employment in Belgium. The most commonly granted categories of work permits in Belgium are the au pair worker, for people coming to Belgium for less than 90 days, and the cross-border worker. The cross-border worker will be covered in the next slide, but I want to also inform you that if a UK national comes to Belgium for less than 90 days, a work permit will be needed. He can be exempted from the visa, or he is exempted from the visa requirement, but at the end of 2022, the European Travel and Authorization System will enter into force. It's known as ETIAS. And this is an electronic system which has been created to prevent illegal travel into the Schengen area. Therefore, it's always important to keep in mind the days non-EU national travels within the EU, and to make sure that the 180-day or the 90 days within any rolling period of 180 days is respected. So cross-border workers, from an immigration viewpoint, individuals residing in the Netherlands, Germany, France, Luxembourg, and the UK are eligible for a cross-border worker status in Belgium if they work in Belgium and return to their home country at least once a week. British nationals are considered third country nationals since the 1st of January. So they require a work permit if they are considered a cross-border worker. For British cross-border workers, it's of course important to make a distinction between those British nationals who are beneficiary of the withdrawal agreement and those who are not. Beneficiaries of the withdrawal agreement are, strictly speaking, already in possession of either an Annex 15 or an N card in Belgium. The N card allows the cross-border worker to easily cross borders, and it is valid for 5 years. If the cross-border situation exists after this 5 years, an extension can be applied for. If you have, for example, a British national who has been in a cross-border situation prior to Brexit, but is not yet in possession of an Annex 15 or N card, this can still be applied for until the end of this year in Belgium. So should that be the case, please take action or reach out to us. If your employee is not a beneficiary of the withdrawal agreement, the general work permit regulations are applicable, as I discussed earlier, and a work permit needs to be applied for. Once the work permit is obtained, the Annex 15 can be applied for at the town hall. And then lastly, our work permit exemptions. Exemptions and their applicable legislation depend on the reason of stay in Belgium. So if your reason of stay in Belgium relates to residency, then the work permit exemptions are determined by federal law. The most applicable exemptions foreseen in federal legislation are those work permit exemptions for EEA or Swiss nationals, for students registered at a Belgian university or school of higher education to the extent that they are exempted from the work permit during school holidays, or to a maximum of 20 hours per week during the school or during the academic year, as long as the work is compatible with the studies. Also, several holders of special types of residence cards in Belgium can be exempted. If your main purpose to come to Belgium is work, then the work permit exemptions are determined on regional level. And the most common exemptions on regional levels are those for business trips, being a business trip of a maximum 20 consecutive days or an absolute maximum per year of 60 calendar days per year. The nature of the services of the business trip is limited, meaning that it may not entail any productive work, and it needs to be limited to closed business meetings, price negotiations as such. The other exemptions mentioned on the slide, yeah, you can read these, but we will not go into detail because of the limited time in this presentation. For British business visitors who are not beneficiary of the withdrawal agreement, they can also benefit from extended work permit exemptions. These are fixed by the Fair Trade Agreement. So British businessmen or women can be exempt from the Belgian work permit if their business trip to Belgium does not last for more than 90 days within the 180-day period. The nature of the activities of the business trip is also limited. It is a bit more extended than the business trip of 20 consecutive days, but still it is quite limited. For example, research and design activities are covered, marketing research, attending trade fairs, giving seminars, and providing after-sales services are covered. Again, actual productive work is not covered. Note that there might be slight differences in the implementation of the FTA by the different member states, so it's always important to double check these and to make an assessment on a case-by-case basis. It is important not to assume an exemption is generally valid. For example, in Belgium, all the work permit exemptions are still subject to the Limosa legislation. For example, if an exemption of a work authorization can be invoked, still it might be possible that Limosa declaration needs to be filed. Therefore, we advise not only to look at immigration legislation, but also make sure Social Security law, tax regulations, and labor law is covered. I think that's it for Belgium. So I pass the mic to my colleague Juliana to cover the Dutch rules.
Hello, good morning. So I would go quickly through the rules that are applicable in the Netherlands. Yeah, I will not go into details here as like most of the things were already mentioned by my colleague Kirsten. But I would like to add that the people that might be still eligible for the advantages under the withdrawal agreement and have been, for example, registered in the Netherlands prior to the 1st of January 2021. And for some reason they missed the deadlines. There has been grace period extended until the 30th of September 2021. So there's still around 1.5 months for these people to apply for their residence document under the withdrawal agreement. According to the information from the Dutch immigration authorities, there are still a couple of thousands of British citizens that haven't used their right to this document. So I would say apply. And let's look at the people that are not eligible for this document. First, I would like to mention that in the Netherlands, it is very recommended for the employers. They would like to bring foreign nationals, including UK nationals, to the Netherlands for highly qualified work to apply for a recognized sponsorship. Recognized sponsorship is a sort of a trusted partner program where the company becomes a trusted partner of the Dutch immigration authorities, and this will bring certain advantages. It is a mandatory condition if the employers are interested in employing highly skilled migrants and scientific researchers. But what is also very interesting is that the decision period about the application or the IND aims to decide within the 2 weeks about the submitted applications, whereas the legal decision period is 3 months. So it is very, very attractive. And then also it is possible to submit the applications with less documentation, because most of the circumstances or most of the meeting of the conditions, it is possible to just confirm with a declaration. Of course, the employer, whether he is a recognized sponsor or not, has some obligations and duties according to the Dutch immigration law. And these are the duty of keeping records and retaining records. Then also obligation to inform the immigration authorities about any changes in the situation of the company or the employees, foreign employees with a work and residence permit. And also duty of care. Within this duty of care is that one of the things is that the employers need to guarantee a good and fair selection procedure, which means that they will also check whether the person really meets all the criteria for the residence permit that they are applying for, and that make sure that they will inform their employees about their rights and obligations while they are staying and working in the Netherlands. Also, very interesting thing is to be able to submit all the applications and notifications online, because this really shortens the whole application process. And the application, once it has been submitted online, is in principle immediately registered within the IND system. So then it is a higher chance that the application will be then further processed faster than if it is sent, for example, via post. So let's have a look at some of the residence permit. Highly skilled migrant is one of the most common residence permits in the Netherlands. And it is especially convenient and an easy way to employ qualified workers. This option is only available for the companies that have become recognized sponsors. And the biggest advantages of this residence permit is the short decision time, less documentation that is necessary for the application, and also that the conditions are quite clear, and if the person really meets all the criteria that are necessary for this permit, then there is a very high probability that the process will be smooth and quick, and there will be a positive decision. There is we mentioned an education requirements. These are not specifically mentioned. It can be also, for example, experience, but the employer has to make sure that the person is qualified for the job that he is being hired for in the Netherlands. The person needs to obtain a local Dutch contract, employment contract for at least 3 months to be eligible for this. And then also the person needs to meet the salary criteria for the highly skilled migrants. These criteria that are mentioned on the slide are only valid in the 2021. They do change every year, and the Dutch Immigration Office usually somewhere in December announces what will be the criteria for the coming year. What is good to mention is that this is a gross amount per month, and only fixed parts of the salary can be counted into this salary criterion. So holiday allowance, for example, is excluded. And the reduced salary criteria is usually available for the young professionals that have just finished their studies, and for graduates that would, for example, also meet the criteria for an orientation year. We will talk about this orientation year in the next slide. So orientation year, it's actually a residence permit that is aiming to attract the young talent to the Netherlands, and it is intended either for the graduates of the Dutch universities or graduates from the foreign universities that are in the top 200 universities in the world. So the IND uses a specific charts for this, and there are certain criteria that need to be assessed, so it is not automatically applicable, and therefore it is good to always check. In principle, the orientation year is applied by the person self, so either abroad they can apply at the Dutch representation, or when they are in the Netherlands, they apply at themselves at the Dutch Immigration Office. The residence permit is valid for 1 year. It is not possible to extend, but the purpose or the idea is that the person will find a highly qualified job within this 1 year in the Netherlands, and then the purpose of the stay will be changed to, for example, a highly skilled migrant. That's what we see the most. And what is also interesting, this person will be during the validity of this permit free on the Dutch labor market, so there are no salary criteria applicable to them while they are holding this permit. And also I forgot. So let's go to the next slide. The intracorporate transfers are in the Netherlands similar as to the Belgium, according to the directive of the EU. In the Netherlands, this program has existed for several years now, and it is basically intended for the transfers within the companies, or within the group of the companies, from a company that is outside of the EU, and the person will be coming to work in the Netherlands. For these transferees, the permits are only valid for manager and specialists only for 3 years, and for trainees for maximum of 1 year. It is not possible to extend this permit beyond this period, but it is possible to change the purpose of stay to a different permit, for example, a highly skilled migrant if necessary. If the person has been, for example, intracorporate transferee for 3 years already, and the company would still like to keep the same structure, or for example, transfer the person to a different country in the EU, there is a 6 months cooling off period between 2-3 years periods of stay in the EU. These persons need to already be employed with an employer outside of the EU for at least 3 months to be eligible to be transferred. So you cannot, for example, hire an employee to be sent directly to the Netherlands. The employee first needs to work for your company for a certain period of time. And the competitive salary is required for these people. There is no, the rule basically, they say that it's a competitive salary, but the rule in the Netherlands is more or less that the persons need to meet the salary criteria for the highly skilled migrants in order to be eligible. There might be certain exceptions, but that would be probably assessed on a case-to-case basis, and then it would need to be really checked also with the immigration office. What would they be willing to accept? And it's also depending, of course, on the industry and the position of the transferee. And what is the advantage of this is also that there's an easier EU mobility, and it is easier to transfer these people within the group of companies, for example, to a different company in a different European state. Yeah. And finally, an EU blue card. EU blue card is actually in the Netherlands not very popular option to choose, and there are only very few holders of the EU blue card, basically. And also many of them are, for example, people that already held an EU blue card in a different EU country, and then they moved to the Netherlands. This option is, for example, used very much in Germany. But for example, when we look at the Netherlands, the conditions for obtaining an EU blue card are much less favorable than obtaining a highly skilled migrant residence permit, and therefore it is much less attractive for the employers. In order to employ or to apply for an EU blue card, the employer does not need to be a recognized sponsor. However, this option is still highly recommended because there will be less administration with the application. The holders of the EU blue card, what is also very important when you look in comparison to the highly skilled migrant, the local contract here needs to be for a minimum of 12 months, sorry. Whereas by the highly skilled migrants, it was only 3 months, and the salary criteria is almost by €1,000 higher, which can make a big difference for the employees. There is also a requirement of providing an evaluated diploma. So the diploma needs to be evaluated by the Dutch authorities, which takes another approximately 4 weeks to for the administration, and then of course there are more costs applicable. The conditions for the EU blue card are country specific, so it is not possible to assume, for example, that once a person obtains an EU blue card in the Netherlands, then he can automatically move to Belgium and work there with a Dutch EU blue card. Unfortunately, in every country, a new application at this moment has to be submitted, and each country will reassess the situation of the EU blue card holder, whether he meets the criteria for the residence permit in their country. There is currently a revision of this directive because the success of in the member states was not as the European Commission has hoped for. Currently, there has been a new proposal sent to the European Parliament for the discussion, and they are expected to vote on this in September, so coming September. So let's hope that soon there will be some news about this. And within this new revised directive, there will be some relaxation of the current rules. The salary criteria will be lowered. Also, the contract should be only valid for 6 months in the current proposal. And there should be also more flexibility for these people to transfer within the EU countries. But let's see what the European Parliament will in the end think about it. Let's look at the next slide and at the rules for short-term workers that are coming to the Netherlands. So this is basically employment or any working activities in the Netherlands that are under the 90 days. These applications are applied for at the Netherlands Employees Insurance Agency, or UWV as we all call it actually in the Netherlands. And this is also the work permit needs to be applied prior to commencement of the activities in the Netherlands. Processing time with the authorities takes around 5 weeks. Also, of course, you need to take into account time that is necessary for gathering all documentation. And UWV unfortunately does not have any online applications, so we are still sending everything via snail mail, and that can take some additional time as well. There are specific categories named on their website. I'm not going to go into the details because there are quite a few of them. But so it is always very important to look what the person is going to say to do in the Netherlands, and which category would apply and what documents are necessary for this kind of category of work permit. The same as for Belgium. For the UK nationals, there is a visa waiver applicable, so the people do not need to obtain a visa to travel. So as soon as the work permit has been approved, the person can travel to the Netherlands and start working. And towards the end of the 2022, there's going to be also this ETIAS system in place, so it will be necessary to obtain an authorization to travel prior to the business trip. There are several categories of work that might be exempted from obtaining the work permit, but we will get to that later. And then a work permit also needs to be obtained for people that would qualify as cross-border workers, so people that are employed in the Netherlands, but they live outside of the Netherlands, and then they commute to their home country at least once a week. And a frontier work document under the withdrawal agreement would be still possible to apply for before 30th of September if the person can prove that he or she worked in the Netherlands before the end of December 2020. And any other cross-border commuter after this period, or that started to work in the Netherlands after this period, would need to apply for a work permit. So it is necessary to keep this in mind for your employees. And then, of course, also the business travelers after January 2021, depending on their work activities, they might need to apply for a residence or for a work permit when they are coming to the Netherlands. And this applies for the work activities from the day one in the Netherlands. So sometimes we hear some common misconceptions that, yeah, when it's only just for 3 days, I don't need to apply for a work permit, nobody will notice. That might be true in most of the cases, but then the one time that they will notice in the company is going to be a lot of trouble, and the person himself as well. And also it is necessary to keep in mind that there's only limited time that these people can be in the Schengen area. So it is the 90 days in any given period of 180 days, and this period cannot be extended. And it is also necessary to keep in mind that any time spent in a Schengen area, so not only for business but also for pleasure, will count into this period. So if your employee spends 4 weeks in Italy, then this time will already be taken into that Schengen time, basically, and that will be the less time that he can then spend working, for example, in the Netherlands. Last, I would like to shortly discuss the exemptions from a work permit in the Netherlands. There are similar as in Belgium, there are some national exemptions, and then there are some extended exemptions that are applicable for the British nationals based on the FTA. The national exemptions are actually very, very limited in the Netherlands. They are all named in the law. One of the conditions is that the main residence of the person needs to stay abroad, and there is no employment agreement with the employee in the Netherlands. And also with most of those exemptions, there are also some time limitations. So it is not an unlimited time, but in some cases it's only several weeks, for example, within a certain period. So it is also very important per exemption to look what the person is going to do. Does the exemption apply, and how can we implement this in practice, and how does this really go, what works for our business? Because we see that a lot of companies are struggling with this new situation, as many of them were functioning where the UK and the Dutch entity were almost one, and then all employees were doing everything together. Or for example, if somebody in the Netherlands got sick, then somebody from the UK would come and work in place of this person for 3 weeks. But this is unfortunately not possible anymore unless the person obtains a work permit before. And therefore it is necessary to plan beforehand. When it comes to the extended exemptions for British nationals, it is basically like Kirsten already mentioned. These are only also there are a couple of them in the trade agreement with the UK. However, there were countries or member states of the EU had reservations against several of these, or one or so. So it is really necessary to look per country and per activity, what are the possibilities, what is necessary to obtain all correct authorizations to work and to perform the activities that are necessary for the business. And I think that that's it from my side, and we can go to question and answers if we have still some time.
Yes, thank you very much, Kirsten and Juliana. Guys, if anyone has a question, feel free to unmute yourself and ask, and then we can have a look at the chat box as well later on if we have anything. It doesn't seem like it. That means the presentation was really clear.
Can I ask a question? Hi.
Of course.
I've been told that travelers from the EU to the UK business travelers should carry a back pocket letter. Is this true?
Well, it really depends. So if you're traveling for business and this is like, it's not going to be a frequent travel, like you are traveling there, let's say once in 6 months for 5 days, literally attending a business meeting, there is really no need to carry a letter. But if you will have a very frequent travel, so once a month or even more than that, it is definitely advisable to carry a letter issued by your employer and potentially the the inviting entity as well, just to outline the purpose of your visit and what exactly are you doing. So you would have to play it by ear and see what the situation is.
Okay, good. No, because we have an office in the UK, and obviously our personnel travels from the UK to the Netherlands and so. I have another question.
Sure.
You said some activities are allowed as business traveler, which is what?
So business meetings, negotiate a contract, attend a seminar, attend a presentation. Those are typical, literally a typical business activities. But as I've mentioned in the presentation, there are certain exemptions that are, that allows you as a business visitor to enter the UK and perform certain duties, as mentioned. For example, manufacturers clause, it does permit you as an employee to come to the UK and, for example, install a product that the company has manufactured. Okay. There are certain other ones as well, but it is definitely recommended to run it by an immigration expert to just double check that it would fall under the exemption.
Okay, good. Thank you.
Perfect. Pleasure. I think we have a few questions. I know it was just a thank you note. Okay. There is a question. I have a question regarding the salary requirements. Since they change every year, does that mean that if you comply 1 year, you might not comply the next? This is for Netherlands.
Yes, so if an employee has applied for his residence permit, for example, in 2021 with a certain salary criterion, then this will be valid as long as the employee stays in the same situation, stays with the same employer and has the same residence permit. Once the permit will need to be extended, for example, in the year 2022, then he will need to meet the new criteria that are valid in 2022. But if, for example, for the whole period of 5 years, an employee gets a residence permit for 5 years, then you don't need to change every year his salary. It only needs to, naturally rise with an inflation, basically.
I just want to begin on that. For Belgium, that doesn't apply. So for Belgium, the minimum salary is also indexed every year. And then on the moment of the single permit application, you have to meet the specific salary threshold, and then every year it's indexed, and then the ministry or the social inspection, they can investigate every year whether or not your employee respects the minimum salary threshold. even though the single permit can be valid for 3 years, and it has been applied for in 2021 based on the salary threshold of 2021. In 2022, the authorities can investigate whether or not you follow the indexed salary requirements. And if not, you will be fined and you will have to increase the salary of the employee. Therefore, it's always important to double check with your provider or with us what the minimum salary requirements are.
Perfect, thank you. Anyone else? Any other questions? If not, you have our contact details. We, of course, share the recording afterwards as well. So you'll have our contact details, and feel free to just simply drop us an email. We'll be happy to assist. But yes, if there are no more questions, then thank you very much, everyone, for attending. And thank you for your time.
Thank you.
Thank you very much. Bye-bye now.
Thank you.